Okay, we're going to talk about law and due process, and this is kind of a law in Texas overview, very, very high level overview of some things that I know that you might be familiar with if you live in Texas and have had any encounter with, different kinds of issues in civil law or criminal law. And I wanted you to just kind of have some sort of a basic background on a few different issues in the law. And this is kind of a thing because if you watch TV, you will get a whole lot of misinformation. You'll get even more misinformation if you get that information secondhand from, say, a friend who's going through a divorce or something like that. That's not the best place to learn about family law. And so, and a lot of times if you've even been through some sort of, court case or issue in front of the court, you might not fully understand what happened if your lawyer didn't explain it to you. So we're going to talk just kind of very high level of basics about the law and due process in Texas. So remember, we've talked about this before, but a plaintiff sues a defendant in a civil case, and the remedy there is designed to, quote, right a wrong and make the plaintiff whole. So the plaintiff says the defendant did something to cause me to have some sort of a loss, and I need a recovery to make me whole. Proof is by the preponderance of an evidence, so just a basic, barely tips the scales in the favor of the plaintiff. Punishment is money damages or telling the defendant to stop some sort of action, stop using that patent, stop parking your car on your neighbor's front lawn, things like that. And you'll not go to jail for something in civil cases. You will only have to pay money or stop doing something. Now, if it's a criminal case, the state of Texas brings charges against a defendant. The punishment, the remedy is designed to punish the defendant for doing some sort of bad action. Proof is beyond a reasonable doubt. So the standard is harder for the state to prove because the stakes are higher. Because punishment is incarceration, meaning you're going to get locked up, or probation, meaning you'll have some sort of restrictions on your freedom. So let's talk a little bit about family law. A marriage can be ceremonial or common. So sometimes you'll hear somebody say that they are common law married, and common law in Texas means you cohabitate, so you live together, you intend to be married, and you hold yourself out as married. So if I live with someone and we live together in the same house, and we say, you know what, we're going to be married. Like, we are husband and wife. We are telling everyone we're husband and wife. Yes, this is my husband. Yes, we're married, things like that. Then we are common law married. A ceremonial marriage is more traditional, where you go get a marriage license and you go to a justice of the peace or the church or something, and you stand up and have your vows, and that is a ceremonial marriage. A big thing in common law marriage is people think, well, we've lived together for 5 years or 10 years or 6 months or something like that. We are just common law married. It actually is a little bit more than that in Texas. Some issues in family law include parents are obligated to support their children, but not support other people after their marriage ends. So we don't really have a big alimony or spousal support system in Texas. That's more of an exception rather than a rule. Child support is calculated in your percentage of net income. So the government will look at your income and take out certain expenses like job-related expenses, things like that. And then that will give them your net income that will be used to calculate child support. Generally, the parent who's obligated to pay support is also obligated to pay health insurance and make sure that health insurance is maintained. Sometimes this can be, negotiated differently. You can divide, say you'll pay the child support, but I'm going to actually pay for the health insurance because I, have better health insurance. I'm able to pay for it, things like that. A lot of family law is negotiable. And then something else you should know is that property acquired during the marriage is community property. And that means if I buy a house with my husband, even if I'm the only one working and he's not working at all, so basically he's not contributing anything to the house or the mortgage, it is still community property. And if we get divorced, it is subject to equitable distribution, not equal distribution, equitable, meaning fair. And there can be 1 million things considered as to whether or not something is, I get more than 50% or less than 50% of the division of community property. So when you are going to have to pay child support, this is what chart is used as the guideline to determine what child support you pay. And remember, this is your net income, your net resources. So, for example, say that I have 2 kids, but I don't have any other kids that I have to support. I only have the 2 kids. And then I would have to pay 25% of my net resources in child support. Now, say that I have 2 kids that are before the court because they were, children of my marriage that I will be supporting. But I also have 1 other child that maybe is from a previous relationship or a future, a current relationship that is not a child of the person I am divorcing. Then I would drop down to pay 22.5% of my net resources. I would get a tiny bit of a credit because I do have another kid that I have to support. And so these guidelines are not not set in stone, but they are pretty much set in stone. This is pretty much followed universally. There are lots of areas of civil law. There's real estate law, which deals with landlord-tenant disputes, also title to land disputes. Do I own this tiny bit of property, or does my neighbor own that tiny bit of property? There's family law that we just talked about. There's probate law, which is not just wills, but also what if somebody dies without a will, and also guardianship. So say I have a disabled adult child, I would want to be the guardian of that child so that I could, manage their finances, manage their income, and also I would report to the probate court yearly to let them know that I'm not just squandering the money. There's business and corporate law that addresses the rights of different business entities and the rights of corporations. Corporations are, when you incorporate a business, you are creating a new legal person. So the corporation is just like a separate person that can be sued. And even though it's not, a person that will sit next to you in court, they're still the person that is being sued, and they will be, represented by counsel, but also represented by somebody in the corporation who can speak for the corporation. They're taxed as a separate person, and there are other business organizations that have different levels of rights. There are limited liability companies, there are limited liability partnerships, there are solo practitioners, which is just small business. It doesn't need to be a single person who is doing that. General partnership just means that you are a partner with somebody, but you both just share the liabilities. There's limited partnerships where some people can be kind of like a silent partner, have a limited liability in the partnership. And then corporations. Their business law, you know, a lot of it deals with how the business is organized and what they could be liable for. For example, corporations can be liable for different things than limited liabilities companies can be liable for, but also anti-corruption laws. So the racketeering laws, there are tax evasion laws, consumer protection laws, to keep all of the business entities operating within the bounds of the law. Contracts is another section of the law, and a contract just means an agreement between two people to exchange consideration. Consideration is the word that's used for like money, but it can also be other things other than money. So my consideration could be that that I'm not going to do some sort of action, or that consideration could be you know, a piece of clothing or just an object. A contract requires there be an offer and then an acceptance of that offer, the exchange of some sort of consideration, so some sort of something you're doing or something you're not doing, or money you're paying. There has to be a mutual obligation, so it can't be a one-sided deal. There has to be something given up by both people. There has to be somebody who has competency and capacity, so you have to have the people that are involved in making the contract both competent mentally and also have the capacity, so be able to speak for, if you're not speaking for yourself, you know, be able to speak for your family or your corporation or your partnership. And most contracts are required to be in writing. There's a whole area of the law that determines whether or not it needs to be in writing, but just to be safe, if you are going to enter into a contract, say to buy a car, you offer to pay you know, $1,000 for the car, and the person accepts it. You are going to exchange consideration, meaning I'm giving you $1,000, you're giving me a car. You're both obligated to do something. That other person's obligated to give up the car. You're obligated to part with $1,000. You both have to be competent, and you both have to have capacity. So you have to actually own the $1,000, and the person actually has to own the car. And you would need to probably put that in writing. And if you did not put it in writing, then you would have to see if that is even enforceable. Generally, if you know there is a contract that is in writing, they talk about it being judged by the four corners of the document. That just means the document, you look at everything in the document, not what's outside of the document. So you wouldn't look at, you know, kind of comments that were made outside of the document if they didn't really have something to do with the agreement. So for example, if I'm in my car buying example, if I say, boy, I sure do love red cars, and you say, well, I've got a red car for you, you're going to love this one, and then we agree, you know, I'm going to pay $1,000, you're going to sell me a car, but in our contract it only says I'm selling you my, you know, 1992 Ford truck, or I'm buying your 1992 Ford truck and I'm paying you $1,000, and it doesn't say that the truck is red, and you show up with a pink car, then we're not going to be able to bring the fact that the car had to be red before the court in order to hold the contract unenforceable, because on its face, within the four corners of the document, the person who gave the car, that didn't specify that it needed to be read, performed what they were supposed to perform within that document. Some contracts are unenforceable just based on the subject matter. So if I offer to pay you $1,000 in order to kill someone, and you accept that, I give you the $1,000, and you're gonna, undertake the work of going to kill someone, and I'm going to give you the $1,000, so there's a mutual obligation, and we're both competent to make the agreement, and we both have the capacity. You own your gun, I, have my $1,000, and even if we put it in writing, that's not enforceable. You can't enforce a contract for something that is illegal. So generally contracts are required to be in writing, but some oral or implied contracts are enforceable too. And so just because you don't have a written contract doesn't mean that you don't have to perform as you promised to perform. Okay, let's talk about something called torts. This might be something that you've heard of before. Torts are just civil crimes, so it's something that you would think would be criminal, but it is actually going to be handled by the civil court system, and it's going to not put somebody in jail. It's going to require somebody to pay some money or, take some certain action. There are intentional torts like assault, battery, false imprisonment, trespass to land, trespass to chattels, intentional infliction of emotional distress, and these all require there to be some sort of an action, some sort of an intent to cause, to commit that action, and then some damages that result. So, let's just go through each of them, and I'll give you the elements just because I think it's a little bit interesting. So assault means that the defendant causes an act. So I, raise my hand to you. The defendant intends to cause the victim imminent harmful contact. So I want to scare you by raising my hand, pretending like I'm going to hit you. And the action of me raising my hand causes you to reasonably believe that you're going to be hurt. So you're actually scared that I'm going to hit you. That's assault. Now, if I actually do all of those things and I come in contact with you, then that becomes battery, if I actually do hit you. Intentional infliction of emotional distress is where I am intending to act and I am having some sort of a conduct that's extreme and outrageous. So I intend to call you on the phone and say, oh my gosh, your house just burned to the ground. And my outrageous conduct is the source of causing you severe emotional distress. Then that is intentional infliction of emotional distress. Some states have negligent infliction of emotional distress. Texas does not. It has to be intentional. I have to intentionally say something that is going to cause you distress. False imprisonment is interesting because sometimes you'll hear people who are apprehended for shoplifting say I was, falsely imprisoned. What that means is that the person was detained without their consent and without the authority of law. So that means there's no reason to detain the person. So if you're shopping and I say, you have to come back here in this room or you have to stand in this part of the store and you can't leave that part of the store, you are detained. And if you didn't agree to it, then without your consent and without any lawful authority. Trespass to chattels is is a funny, antiquated thing that is, sounds, like a super, come over and with the Mayflower kind of talk, but the basic elements are that you are going on somebody's land or trespassing, and you don't have the consent of that person to go onto their land or to to come in contact with their land. You are interfering with their possessory interests, so they can't actually use their land. And I, intend to actually get on that land. I don't have to cause any damage. I could just, stand in the front of your driveway so you can't actually get into your driveway, and there doesn't have to be any kind of damages required. Trespass to land is that I am interfering with your possession to land, and I'm intending to enter that land. Let's talk about, there's negligence, which is an easier standard than intentional torts. Intentional torts requires some sort of action. Intentional action. Negligence can just happen whether you intended the action or not. So it requires there to be some sort of a duty that is owed from one person to the other. For example, I owe a duty to my children to take care of them. You breach that duty, meaning I did something that means that I wasn't taking care of them. That breach causes some sort of a damage, so causation and damages. So my not taking care of them causes them to have emotional distress, and their emotional distress is they have to get counseling for that. So my being a bad mom requires them to have to go get counseling. Then I could be sued for negligence and have to pay damages in the amount of their counseling. It's judged by a reasonable person standard. So would a reasonable mom have done what I did that was apparently, negligent? So would a reasonable mom have left their kids alone while they went to work, or that kind of thing? You'll hear about libel and slander. Those are things that when somebody says something bad about somebody else, it's a false statement published to a third party. And so what it means is, I say something, if I just say something to myself in the privacy of my own bedroom that nobody ever hears, then that's not really libel or slander. But if I say it outside to my neighbor, that's published to a third party. And there's, some sort of a fault amounting to negligence, meaning that I shouldn't have, I was not acting reasonably when I said that. And there are damages. So libel is something that's written, slander is something that's spoken. So those are the differences between those two things. And the damages, you have to show damages. So if, if I say something bad about you to my neighbor, and it was, something that is unreasonable for me to say, then, and you don't have any damage, there's no fallout, it's just your neighbor doesn't like you anymore, maybe doesn't smile at you on the street, then there's not any damage. But if there's damage in that, maybe your neighbor doesn't hire you for a job anymore, then that's your damage. Now, recovery and torts are money damages, either to compensate the plaintiff, so kind of right your wrong, give you what you would have gotten had there not been the tort committed, or punish the defendant. So this is where you get the punitive damages, when a company gets has to pay all the medical bills, but then also gets $1 million that they have to pay as punitive or punishment, or both. Now let's talk about some libel and slander. This was interesting. In 1996, Oprah had a talk show, and she was talking about food safety on her talk show, and the subject of mad cow disease came up. And mad cow disease was a big deal at the time, because if a cow with mad cow disease was slaughtered, and that beef was turned into, if the animal was slaughtered and their beef was used to make a hamburger or something like that, and you ate that hamburger, you could also get sick. And so, and it was kind of a big deal in the UK. It wasn't really a big deal in the United States, but something interesting to discuss if you're Oprah, nonetheless. And when she was talking about it, she said something to the effect of that, this talk of mad cow disease has just stopped me cold from eating another burger. I'm stopped. So basically, she said, I'm not eating burgers anymore. The beef industry sued Oprah pursuant to the False Disparagement of Perishable Food Products Act of 1995. So an act that said you can't say false things about perishable food products. And they sued her, and it was a bunch of Texans in the beef industry that sued her in Amarillo, Texas, in federal court, and she went through trial, and she won. Now, when we talk about damages that are intended to punish a company, it is for some sort of outrageous conduct. And so this is where you see damages that or verdicts that are really big, like the millions and billions of dollars. That is because the company had some sort of, arguably had some sort of conduct that was outrageous and terrible, and they needed to be punished for it. One example of this is somebody at Ford wrote a memo when there were a lot of instances of Ford Pintos that were catching fire when they got into accidents. And so somebody wrote a cost-benefit analysis memo that said that, if we do the recall and recall all the Ford Pintos, it's going to cost, more, basically, because we would have to recall 11 million cars and 1.5 million light trucks. We'll have to spend $11 per car or truck to make that fix. So that's 12.5 million times $11. And that's going to cost us 137 million. If we're going to recall the cars and trucks, fix it so that if you get in an accident in a Ford Pinto, you're not going to burn to death. But if we consider that we'll probably have 180 burn deaths, 180 serious burn injuries, and maybe 2,100 burned vehicles that we would have to replace. And the cost, say we'll have to pay $200,000 per death, so that times 180. And say we'll have to pay about $67,000 per burn injury that somebody sustains, so multiply that by 180. And say that we have to replace, 2,100 burned vehicles, and we'll pay $700 a vehicle. Well, that only costs us $49.5 million. So you see it's cheaper to not recall all the Ford Pintos and make the safety adjustment and just to settle or litigate the cases when somebody dies or burns to death, or their car burns up. This is something that's considered outrageous conduct and something that Ford had to pay a lot of damages because of. So there's some other issues in civil law that I really want you to know about. First is contingency fee payments. This is something where somebody says you don't have to pay unless you recover. So lots of times in car wrecks, you're not going to have to pay your attorney until you get some sort of recovery. You win at trial. And so we'll talk about that on kind of in the next slide, because I want to go through that and let you know kind of what that actually looks like in practice. Another issue in civil law is tort reform. There's all kinds of laws that try to stop crazy lawsuits but allow legitimate lawsuits. So, but the big gray area is what's considered a crazy frivolous lawsuit and what is an actual lawsuit. Is it crazy and frivolous to be able to sue your doctor for a botched operation and recover $1 million? Is that too much, or should you only be able to recover $250,000? That kind of thing. Frivolous lawsuits increase the cost of doing business, so it makes it more expensive because, for example, doctors have to get more insurance, and they increase the cost of goods and services. So if there's a bunch of crazy lawsuits against doctors are going to have to charge more in order to pay for more insurance to protect them against these crazy lawsuits. But you need to watch in tort reform to make sure that the people who are doing bad things are still being held accountable. In Texas and in the United States, we have what's called the American rule, which means that everybody pays their own costs associated with court. But there's an issue of whether we should have a loser pay system that says that if you are being sued and you offer a reasonable amount of money to settle the case and the person rejects that, but then you have to go to court, you have to defend yourself, spend all your money in legal fees, and the award is less than the amount that you would have given them anyway, then the loser has to pay if they reject a reasonable out-of-court settlement. And then another issue is in eminent domain cases. And we'll talk about eminent domain, probably not much because it's hard for me to say. And what that means is that the government can take land for public use if they give reasonable compensation to the person that they're taking it from. So the state wants to build a highway and it's going to need to run through the corner of your farm. They can take that corner of your farm for public use, the highway, as long as they pay you a reasonable amount of money. But there's a whole issue of whether, is this really public use? Is it really necessary? Is this a reasonable amount of money? Those kinds of things. So let's talk just briefly about contingency fees. When you see something like Jim Adler who says, you're not going to have to pay unless we win your case for you. Well, what happens is usually you have to pay 40% of the recovery less expenses. So what that looks like is, say you go to trial and you have $100,000. So what they will say is, okay, we get 40% of the recovery, So we're going to take 40% of $100,000, and then we're also going to deduct all your expenses. So $5,000 for the investigation, $20,000 for expert witnesses, $1,500 for all the depositions we had to do, blah, 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 all the way back. Then you see that, well, for example, in this example, if the recovery was $500,000, when you consider that the expenses are taken out of that, that is $422,000. That is your recovery. That means you only get to keep, after you pay your attorneys, you only get to keep $253,000 from your $500,000. So realize that when you're paying in a contingency fee case, you are actually paying for your attorneys. You're just paying on the back end instead of the front end. And it's a gamble for the attorneys. So it's something that they are going to make sure they only take cases that they think they're going to be able to win, and they are going to make sure that the amount of the money that they're able to recover is enough to make their business worthwhile. Okay, so let's talk about criminal law, and I have to give a big giant asterisk here. I spent a summer in the district attorney's office and I worked for a judge, but beyond that, my criminal law knowledge is limited to my time in law school. So I will give you some information about criminal law. I'm not a criminal lawyer though, so you should really take all of this as just kind of a basic knowledge, and before you use it as a basis to commit a crime or something like that. Generally, crimes are state law crimes. There are very few federal crimes that people are going to be charged with kind of on an everyday basis. We see the federal crimes and things like when you take somebody across state lines, or kidnapping, or you do business across state lines. Things like The Firm, the movie and the book by John Grisham, or I just watched the trial of the Chicago 7. That was a federal case where you are, crossing state lines to commit some crime. So federal crimes are crimes that are committed on the high seas, committed on federal property or reservations, crossing state or national boundaries, interfering with interstate commerce, and committed against the national government or employees who are in their official business. So if you do something to the President of the United States, it's a federal crime because he's a member of the national government engaged in official business. There are two types of crimes. Felonies are serious crimes, and that's where there's serious bodily injury involved. And then misdemeanors are minor crimes. So a traffic ticket is a misdemeanor. Sometimes small damage, like small theft, is a misdemeanor. So felonies versus misdemeanors, like a misdemeanor traffic offense is speeding, or driving while intoxicated on your first offense. But if you drive recklessly and injure someone, or you are driving while intoxicated and it's your third offense, then those are felonies. For in the drug arena, it's a misdemeanor to possess certain amounts of controlled substances or paraphernalia that is used to, like a bong or something like that, used to use those drugs. But it is a felony to possess large amounts of drugs or some sort of evidence of intent to distribute. So, maybe a log with all of the names of all of the people you are selling your drugs to. That would that would put it in the felony arena. One issue is whether or not there are victimless crimes. And if there are victimless crimes, what are they? And this is something I would love to debate with all of you, because it's something that's not settled. Is gambling a victimless crime? Say if, is gambling, like, say you play in an illegal poker game, but nothing you do in that illegal poker game other than play poker is affecting anyone else. It's not like you're not paying your mortgage, or you're, gambling away your children's college or something like that. Is that a victimless crime? Software piracy, is there a victim in that? Public drunkenness, suicide, who's the victim in suicide? It's basically murder, but the victim is the person. Prostitution, drug possession, are these crimes that have a victim? And if they don't, should they be punished? There's not an answer to this. This is something I would like you to think about, though. Sometimes you'll hear about white-collar crimes, and white-collar crimes are crimes that involve money. White-collar, so you would think of people in business suits that would be committing these crimes. So embezzlement, which is like skimming money off the top. Tax evasion, not paying the taxes you owe. Bribery, paying somebody to do something or not do something. Price fixing, so getting together with everybody who sells donuts in your area and saying, we're going to charge $10 a donut, and so we're going to price fix this. Insider trading, so if I hear that a certain stock or a certain business is going to make some giant announcement, and I buy all their stock up the day before because I know it's going to get really valuable, then that's insider trading. The victim is a person, but also the economy, and so the public in general. And in white-collar crimes, there's not, really bloodshed. There's no violence. It's and it's committed by people who wouldn't really fit the general definition of a criminal. So it's people who are educated or wealthy, or, like I said, wearing a shirt with a white collar, a business suit. There are some very Texas crimes that are still on the books. So there's cattle rustling, which is, stealing someone else's cattle. Illegally milking someone else's cow is on the books in Texas. You're not allowed to do that. So if you ever get the inclination, you should probably just not milk someone else's cow. Drunk texting 911, don't do that. And interfering with hunters. So if you get the idea that maybe you are going to save Bambi and his mom, and so you're going to chop down all the trees that have deer blinds built on them, don't do it. It's a crime in Texas. Now back at white-collar crimes, you all hopefully remember Martha Stewart, who I guess now is famous for taking selfies in front of her pool, but historically has been famous for, putting together the perfect Thanksgiving dinner or something like that, perfectly decorated table, things like that. So she went to prison because she sold all of her stock in a company called M-Clone, and 2 days later, the stock fell when the FDA announced that they had not approved one of the company's big products, and the evidence showed that she had some sort of an inside tip or inside knowledge that that announcement was about to be made, so she dumped her stock. She got 5 months in prison, 5 months in home confinement, and 2 years of probation. Another white-collar crime was the school admission scandal. Again, this was committed by wealthy people that you would not normally think of as criminals. For example, Felicity Huffman paid $15,000 to have a test proctor adjust her daughter's SAT answers. She served 14 days, well, she served 11 days of a 14-day sentence, was given 1 year of probation, 250 hours of community service, and a $30,000 fine in exchange for her paying $15,000 to cheat. Now, there's something called the FBI Crime Index. That is when people talk about crime rates in a certain area, they're using information from this FBI Crime Index. And what they do is they include certain crimes in this. And so it's things like murder, manslaughter, rape, so not statutory rape, where somebody has intercourse with somebody under the age of 16, but forcible rape. Robbery, aggravated assault, which just means brandishing a gun, hurting somebody with a gun, burglary, grand theft, and motor vehicle theft. And so when you look at crime statistics, they are using the FBI Crime Index as what they are counting as a quote crime. So what makes somebody commit a crime? Lots of different issues that people study to determine what does the normal criminal look like. Is a criminal a certain age or race and ethnicity, certain gender? Do certain genders commit certain crimes with greater propensity? Do they have a certain income level, educational level? Are they drug addicts? What kind of access to weapons do they have? What kind of family background do they have? Where is their residence located? Do they live in a small town? Do they live in an urban area? Do they live in an inner city? Things like that. All of these things are studied and tried to map out kind of what is the reason why some people commit crimes and other people do not. So juvenile justice is different from the criminal justice system for adults. So here the goal is to rehabilitate the juvenile as much as it is to punish them. There's not really a goal of rehabilitation in the adult prison system. Juveniles do not have the right to a public trial, and there is not a right to a grand jury indictment, and they don't have the right to bail necessarily. These are more like civil cases than criminal cases. They want to, have the option to not necessarily just throw somebody in jail, put them on probation. They want to have other options like boot camp or state schools or halfway houses or some sort of other creative punishment in order to hopefully rehabilitate the juvenile. If somebody is over 13, then they can be tried as an adult for a serious crime. But that is, the exception, not the rule, and it is something that, is not the default. It's something the prosecutor actually has to ask for. There are lots of different theories of punishment. So when trying to decide punishment guidelines or punishments that should be associated with certain crimes, these are the thoughts of, why are we punishing? Are we punishing so that justice may be served, or vengeance can be served by, on behalf of the injured person or the deceased person? Do we want to isolate criminals to protect society? Do we want to invoke some sort of punishment that's going to deter this person specifically from committing this crime again, or any crime again, or generally all society to commit this crime? So do we want to make the punishment so harsh that other people see what the punishment is and say, oh yeah, no, that's too much of a gamble, I'm not going to do that? Or is our punishment system designed to rehabilitate the offender. And I will say that generally it is, a deterrence and an isolation theory that is, surrounds the justice system, and not really a rehabilitation theory. So when we're looking at the victims of crimes, what makes somebody a victim? Is there a certain income level, a certain criminal background? Is there a certain age or ethnicity or location where the person lives, like urban versus rural, things like that? There's a lot of information studied a lot of statistics analyzed to determine whether or not somebody is more or less likely to become a victim. That way you can kind of work yourself out of that. If there's, if you are in a certain group or a certain area where there are more victims in that area, then you can try to leave that area so as to hopefully avoid being a victim of a crime. There are a lot of issues surrounding victims' rights, and victims' rights in Texas are protected because they are allowed to be informed of investigations and court proceedings. So, if they're allowed to know when the person that was accused of committing the crime against them is going to be in court, or, whether or not they've made an arrest, or whether or not they've found, corroborating evidence or something like that. Their victims are allowed to provide a victim impact statement that is used by the court when determining sentencing. And so the victim impact statement allows the victim to speak directly to the court and let the court know what kind of impact the crime had on them. And then also there's the Crime Victim Compensation Fund that helps victims with extreme personal hardships. And this sounds really good, so say it sounds like it would be something like if your car was stolen, then the Crime Victim Compensation Fund would help you get a new car. But that's not really how it works. In practice, there's really not enough funds for that. There are, but there is some compensation that is, can help with some expenses for some crime victims in extreme circumstances. So remember when I talked about what the crime index, the FBI crime index, and those crime index crimes, that is what is used when you're trying to say what crimes per 100,000 in the population. So in 1990, were they counting how many people passed hot checks, and it was 8,000 per 100,000 people? No, it was the violent. It was the index crime. And so Texas's crime rate has decreased steadily since 1990, and it is now half of what it used to be in 1990. But the violent crime rate has stayed pretty steady since then, and has not decreased at the same level. There seems to be more crime. It may seem to be a more dangerous world in now than there was in 1990, because there's an increase in reporting, like publicizing school shootings, church shootings, things like that that are larger scale criminal activity that garners a lot more attention than you know, a drive-by shooting or something like that. Okay, the last thing I want to talk about is due process. And so due process is the protection that is given by the federal Constitution to everyone. So, and it's protects people from state action as well through the 14th Amendment. And due process just means that there has to be some sort of a procedure in place that is going to protect a person from being taken advantage of. And so there are lots of different steps in the criminal process, and there are due process guarantees at each of those steps to try to make the system as fair as possible. So in the when a crime is being investigated, in the search phase, when police are searching for evidence, the protection that is given is that the police must have probable cause to suspect that there's, you know, this person's committed the crime or has evidence of the crime, and it must be a reasonable search. And that is, I kid you not, that is like a whole class in law school. So search and seizure is a big issue. And what happens if there is not a reasonable search based on probable cause is that the police are not allowed to use that evidence in trial. And so that's a pretty big reason why they must have probable cause, because otherwise that evidence will be excluded. At the arrest phase, after the police you know, have determined that somebody should be arrested for the crime, there also has to be probable cause, and it has to be a reasonable arrest, and there have to be Miranda warnings. Miranda warnings are the warnings that were based on a case involving Mr. Miranda, and they are the things you hear in every movie. You have the right to remain silent. Anything you say can and will be held against you in a court of law. You have a right to an attorney. If you cannot afford an attorney will be provided for you. And so before somebody is, you know, questioned, they have to have the Miranda rights given to them so that they know that whatever they say could be used against them, and that they have the right to not say anything, and so they would not incriminate themselves. The next step in the criminal process is the arraignment, where after somebody is arrested, they must be taken before a judge in order to plead guilty or not guilty and determine whether or not they are going to be entitled to bail, and know what they're being charged for. And this is another instance where there's the right to remain silent. Somebody doesn't have to say anything. And they are, you know, there is a right to bail, there's a right to an attorney, and there is a right to know what charges are being brought against you. No secret of trials, no, you know what you were arrested for, you know what you did kind of thing. These are all protections put in by the Constitution to avoid such things. Another due process protection is the next phase, the grand jury. So the grand jury is a place where only one side of the evidence is heard, and it is the prosecutor, the state, coming before a jury of people saying, here's all the evidence I have, and the grand jury says, yes, that's enough evidence for you to be able to proceed with trial, or no, you don't have a case, so we're not going to let you keep this person locked up or out on bail, you know, and basically harass them for something that you don't have any evidence that they did. And so this is where you get the formal charges filed if the grand jury chooses to indict, meaning chooses to let the prosecutor go forward with their prosecution. And then after the grand jury, there are pretrial hearings where somebody can say, this is a judge that is not fair. This is a place that is not fair for me to have to be put to trial. You know, I am incompetent to stand trial. I don't understand what's going on. I'm mentally incapable of standing trial for this offense, things like that. And it's another time for somebody to say, I am not guilty of this crime. The plea bargain phase is where the state may say, look, if you can agree that, you know, you're guilty, and we don't have to go through trial, you can, you know, just get probation, or you'll get a lighter sentence. We'll recommend a lighter sentence instead of having to proceed through trial, proceed through jury selection, things like that. And so it's an opportunity for someone to enter into their own kind of voluntary punishment. And then if there's a trial, there are protections there where the person has a right to an attorney. They have a right to a jury of their peers, meaning a diverse jury, a jury taken from people in their same area where they're charged with the crime. And they have the right to have a jury that is given the right kind of law, the right statement of the law, meaning the right jury charge. They are presumed to be innocent until proven guilty. So they are presumed to be not guilty of the crime unless the state is able to prove that they had committed the crime. And also they don't have to testify against themselves. Finally, after there's a trial, if somebody's found guilty, there's still protection for that person through the process. The protection in sentencing is that it must be reasonable. The judge or the jury must use reasonable guidelines in order to sentence somebody. They have a right to bail if they are, you know, going to appeal the case, if they're going to appeal the verdict. And you don't have to stay in jail, you know, like, yeah, you can appeal the case, but you're going to have to stay in jail the whole time. You might have to if there's a reason to deny the bail, but there has to at least be an opportunity for you to be heard on, you know, please can I have bail while I am appealing my case. So these are all the protections that are procedural process protections that are guaranteed by the law for criminal defendants. So that is criminal law, civil law, law in an hour, and that is definitely a broad overview, but I wanted you to have enough kind of a background so that when you're watching a TV show that involves a police scene or you know, a divorce or something like that, or you're hearing stories that people are talking about, reading books, you know enough of a background that you're able to understand and put these things into context.